The first mistake is signing a term sheet as soon as they receive it. So
Okay.
I've seen lots of founders, and I appreciate people can get sort of quite excited about receiving a term sheet from someone to invest, but then they immediately sign it before having spoken to a lawyer or run past someone what might be what I call market standard. So actually, when that happens, it's often very difficult to sort of unwind that. So you can, it's very difficult, although term sheets aren't legally binding, it's incredibly difficult when you go forward to negotiation of these documents to say something else. And more often than not, the lawyers acting for the investor will say, well, no, because that's not what the term sheet says, right? So it's often really difficult to go backwards. So I think one of the biggest things is when someone receives a term sheet, I often say to people, please just send it to me. Honestly, it will take me 5 minutes. I will tell you whether it's market standard. Or if there's anything that's sort of glaringly, obviously strange. And, you can go and discuss it with that investor. So I think that's one of the biggest points. I think secondly, I don't know how many points you want on this.
Let's do, I don't know, 3, 4.
We talk all day. I think secondly is not being prepared in terms of your own company. So, it can be as simple as not having, let's say you have co-founders. Right. But you haven't properly documented the arrangement, or actually you haven't even issued the shares, and you don't know how to do it, or you haven't spoken to someone about it, or you don't really have sort of agreements in writing with suppliers. I don't know, customers, whatever you are, whatever is essential for you as a business. But I suppose coming to an investor without these things, it can be negative, and sometimes worst case can actually kill a deal, depending on how risk, I suppose, averse that investor is, once they ask questions. Right. So I suppose on that point, I suppose it's more about being prepared. I think that goes back to the question you were asking earlier about when should someone come to a lawyer, as soon as possible, right? Because it's these things that we can say to you, have you done X, Y, Z? Let's do a quick health check. Let's get you prepped. Right. And we often do these exercises. We call them health checks, pre-fundraise health checks, where we almost send you an investor due diligence questionnaire as if we were the investor. And you go, oh gosh. And then you go away and you go, what haven't we done? And we work out what's important. So yeah,
I've done, sorry, I've just, it is coming back to me because I've done a few pitches myself, and when the investors start asking questions, and of course ultimately you cannot be prepared for all of them, but apparently I wasn't prepared for any of them, so it was really eye-opening. And when they ask you like how you're going to make money, or like how, but that other one is actually very obvious, but a lot of times you're just stuck there. And so this is, I think, a great exercise, and you should definitely do it. And I cannot emphasize it more. There are so many places where you can practice your pitch, so as many times as you can. That's a very good one, David. Thank you for reminding us. But sorry, I interrupted you.
To be honest, I suppose that was probably more than one, because I suppose it's just being prepared generally. But I think I probably I suppose I'll just say this as a final point. There's lots of points obviously, but I think remember that the investors are sophisticated. So I've seen a lot over the years, quite a few founders thinking they're almost slightly bigger than they are, maybe more intelligent than they probably are, but I think that can actually be a quite negative thing. I think remaining humble and remembering these investors are incredibly sophisticated, so when they ask questions, they're asking a question for a particular reason, not just for the sake of it. So I think that's a really important thing.
Oh wow, yeah, I think this is very unusual, but yeah, a lot of times I think startup founders approach, especially angel investors, just like money bags, basically.
Yeah.
And yeah, so you've got money, why not invest in me? And that's usually a very big mistake, but yeah, that's a good one. I like it.
Actually, one final point, which is actually really important. It's probably more focused for UK fundraising, but I would imagine other European jurisdictions probably have similar financial services laws. But when you communicate to potential investors about a fundraise, or an issue of shares in the company, you've got to be quite careful, because our laws don't actually allow us to do that unless they are two high net worth individuals or sophisticated investors. So there's generally some language which is a little bit like a disclaimer, which accompanies any communication to potential investors. So I often tell people that, and I often give them the language for free, because I don't want to see people get burnt. So that's quite important.
Right.
So I think, just as a general point, always check. If you're a UK company, German company, whatever company you are, check if there's any such laws.